Right. Okay. This is administration of law. It's done on the 7th of February 2023. The time is 15:44. This is Learning Unit 5, Administration Action. Let's get moving. Working your way through this learning unit should enable you to explain why it is important to establish whether administrative action is involved. Set out the definition of administrative action is provided in section 1 of PAJA. Discuss the various elements of this definition. Determine whether action will not qualify as administrative action. List the traditional classes of administration action. Briefly explain why this classification has been made. Reflect on the legal force of administrative action. The outline of this learning unit is as follows. The definition of administrative action. 5.1.1 Section 1 of PAJA. 5.1.2 Action that does not qualify as administration action. 5.1.3 Judicial interpretation of administration. 5.1.4 Constitutional instruction, background of section 1. 5.2 Okay, I forgot to scroll up here. Okay, we move to 5.2. The need to establish whether administrative action is involved. 5.3. The classes of administrative action. 5.3.1. The three classes of administration action and the distinctive characteristics of each. 5.3.2. Separation of powers are three classes of administrative action. 5.4. The legal force of administrative action. 5.4.1 When does administrative action take place? 5.4.2 Termination of legal force administrative action, and then 5.5 is conclusion. 5.1 The definition of administrative action. Section 1 of PAJA. Section 1 of PAJA. Administrative action means any decision taken or failure or any failure to take a decision, by A, in an organ of state, when dash 1 exercise a power in terms of the Constitution or a provincial constitutional apostrophic, or 2 exercise the public powers, the power exercising a public power or performing a public function in terms of any legislation, or B, a natural or juristic person, other than any organ of state, when exercising a public power or performing a public function in terms of an empowering provision which adversely affects the rights of any person in which has a direct external legal effect but does not include AA. The executive powers and functions of the national executive include the powers or functions referred to in section 79, paragraph 1 and 4, 84, subsection 2A, B, C, D, F, G, H, I, and K. 85, subsection 2B, C, D, and E. 92, subsection 2, 91, subsection 2, subsection 3, subsection 4, and subsection 5. Hey, this is disturbing. Okay, this is PAJA. As you can see, I'm not going to read it. I'm just gonna scroll it slowly so that when I look at it later, I can read it. There is BB, CC, the executive powers or functions of a municipal council. DD, EE, and then we move to FF. Decisions to institute or continue a persecution. Move to GG. HH. I. It is crucial that you understand the definition in section 1 of PAJA and memorize it, at least up to the exclusion. We encourage you to do so before you continue to look at the rest of the learning unit and guide. The definition of the administrative action can count around 13 marks for assessment purpose. You should therefore be able to identify the exclusion in a set of facts. The following definitions for purpose of section 1 are important. Administrator, decision. Administrator means an organ of state of any natural or juridic person taking administrative action. Decision means any decision of an administrative nature made, proposed to be made, or required to be made, as the case may be under an empowering provision, including decision relating to making, suspending, revoking, or refusal to make an order, award, or determination, giving, suspending, revoking, refusing to give a certificate, direction, approval, consent, or permission, issuing, suspending, revoking, or refusing to issue license, authority, or other instrument, imposing a condition or restriction, making a declaration, demand, requirement, retaining or refusing to deliver up an article, or doing or refusing to do any other act or thing of any administrative nature, and a reference to a failure to take a decision must be construed accordingly. Empowering provision means a rule of common law, customary law, or an agreement, instrument, or other document in terms of administrative action as purportedly taken. Failure in relations to the taking of decision includes refuse to take a decision. Organ of state-based means assigned to in Section 239 of the Constitution. Please note, you must make sure that the definition of administrative action and do not confuse it with the definition of organ of state. They share many of the same phrases. Remember, the organ of state is an entity and administrative action is a decision. I'm going to stop here. I'm going to stop here for today. Danko. 'Good morning. We are back with administrative law. The date today is the 8th of February 2023. The time is exactly 10:54. 5 minutes to 11. We're going to move. We're doing Learning Unit 5. We're proceeding with Learning Unit 5. So let's move to the right page, which is page 54. Let's go. Page 54. 54. There we go. We're going to start here decision. We see first that action will qualify as administrative action when it takes the form of a decision. Reading on, we see that what constitutes the decision is explained in the definition of decision. What is noticeable about the definition of a decision is its scope. The definition provides several examples of conduct that will qualify as a decision. Return to the definition to see what the legislature regards as a decision for PAJA purposes of PAJA. Regards as a decision for purposes of PAJA. It even includes decisions that have not yet been made, but that have only been proposed. A decision will also qualify as administrative action when it involves the refusal to take a decision. See the definition of failure above. Moreover, the examples are not limited to those given, since the legislature also included a catch-all paragraph G to the effect that a decision also includes doing or refusing to do any other act or thing of an administrative nature. In Melanie and others versus City of Johannesburg and others, 2006 subsection 5 SA 69 GJ, the South Gauteng High Court had to decide whether the Johannesburg decision regarding the progressive realization of the right of access to adequate housing, Section 26 of the Constitution, for residents of the Slovo Park informal settlement amounted to administrative action. The residents argued that the state should fulfill its Section 26 obligation in terms of upgrading of informal settlement policy. Which the city neither decided to implement nor not implement. The residents further argued that the city's failure to apply upgrading of informal settlement amounted to administrative action, which is reviewable under PAJA. The court held that the decision to implement a policy in a specific case amounts to an administrative decision, since it affects the rights and the legitimate expectation of individuals. It also further decided that city's failure to apply the UISP was unlawful. Does the extensive description of the decision mean that virtually any type of action or conduct will qualify as administrative action? For any answer to the question, need to turn to the element of an administrative nature. 2 of an administrative nature and inquiry to the element of administrative nature bring us to the distinction between the constitutional law and administrative law. Both constitutional law and administrative law form part of the public law and are concerned with the way the state is governed and with the distribution and exercise of public power or authoritative power. Although we cannot distinguish between the two branches of law on the basis of their nature and content, the following distinctive is nevertheless drawn for the sake of convenience. Constitutional law. Constitutional law deals with the actions of an interaction between the organs of state of the three branches of government: the legislature, the executive, and the judicial. It regulates the powers of the highest organs of state, such as of the president and his cabinet. It also regulates the powers of the judiciary. Furthermore, it controls the legislative powers of parliament in the national sphere, of the provincial legislature in the provincial sphere, and of municipal councils in the local sphere of government. Administrative law, in contrast, is concerned with only one branch of the state's system, namely the executive. More specifically, it is concerned with that has been described as the conduct of the bureaucracy in carrying out daily functions of the state. See Gray's Marine referred to above. In other words, constitutional law and administrative law have the following different areas of focus. Constitutional law is concerned with the structure of the organs of the state at the highest level, i.e. the parliament, the executive, and the judicial. It also concerned with the matters such as the formulation of policy by government, a matter of politics. This policy is usually set out in legislation. See glossary for the definition of the constitutional law and government. Administrative law is concerned with the day-to-day business of implementing and applying this policy. We propose that the element that the decision needs to be of an administrative nature merely stresses that the decisions need to be related to the day-to-day business of implementing and administering policy. Decisions at the highest level by the executive, the legislature, and the judiciary do not constitute administrative action. We will return to this topic when we discuss the list of specific exclusions below. Excuse me. This element will also be addressed once again when we briefly look at the classes of administrative action in the last part of this learning unit. Under an empowering provision, we see further that the decision must be taken in terms of empowering provision. Empowering provision is defined as a law, a rule of common law, customary law, or an agreement, instrument, or other document. This element underscores one of the most important features of administrative law in the general and administrative action in particular, that the exercise of public power or the performance of the public function must have an authoritative foundation of some kind. In other words, the decision must be permitted by law, not only legislation but other kinds of empowering provision, which have an authoritative basis. Note that this particular element is further echoed in the requirement that all administrative action must be validly exercised. This particular feature forms the subject of part 3 of the study guide when we discussed in the next 5 learning units. Learning unit 6 to 10, the requirement for just and valid administrative action. And then we move to organ of the state or natural or juristic person when exercising public power or performing a public function. The action of organs of state as defined in section 239 of the Constitution will qualify as administrative action when they exercise power in terms of the Constitution or provincial constitution, or where they exercise public powers or perform public functions in terms of legislation. Note that PAJA also allows for administrative action to be carried out by persons other than the constitutional defined organ of state, that is, natural or juristic persons. However, these actions will only qualify as administrative action when these persons exercise public power or perform public function in terms of an empowering provision. In Eden's Security Service in Sisi and others versus Cape Peninsula University of Technology and others, 2004, ZWZ CHC 148, the court held that an institution like the university was excluded from the definition of organ of state, which meant that its procurement processes should not be regarded as administrative action for purposes of Section 33 of the Constitution. This decision is open for criticism on the basis that some private bodies may perform administrative action if their conduct is public in nature. In Association of Mine Workers and Construction Union and others versus Chamber of Mines South Africa and others, 2007, subsection 3SA242, CC, the court had to decide whether the power afforded by Section 23, subsection 1D of the Labor Relations Act 66 of 1995, LRA, was indeed public. This section authorizes an employer to extend a collective bargain agreement between it and a majority union. Also, to employees who are not members of the majority union, the court held that the question whether a power function is public was complex and needed to be determined on a case-by-case basis. Such powers should be scrutinized on a continuum between what is considered to be public and private. All relevant circumstances should be taken into account, including the extent to which the power of conceive its relation to the statutory framework, the impact of the power of the public, and whether there is a need for the power to be exercised in the public interest. Even though the power was held to the public to be public, it was not for an administrative nature, since the exercise thereof did not amount to the administration of policy or statute, but rather by way of agreement between the parties. Adverse affects the rights of any person. Adversely affects the rights of any person. To qualify as administrative action, the decision's effect must be adversely affecting the rights of any person. This requirement is closely related to the next few learning units, where we will inquire to the lawfulness or to the use of language of the Constitution, the legality of the administrative action. However, for the purposes of our present examination of the elements of administrative action, suffice is to say that by including this element, the legislature's intention was ostensibly to create a restriction to the reach of PAJA. Thus, only when the action imposes a burden on someone, e.g., in our example of the suspended educator in scenario 3, the suspension imposes a burden on the educator, which shall action qualify as administrative action. That has a direct external legal effect. Just as the element that the effect of the decision must be adversely affect the right of any person, the element that administrative action must have a direct external legal effect is aimed at restricting the reach of PAJA. This element was a late addition of the definition of administrative action, and the legislature adopted it from German Federal Law of Administrative Procedure of 1976. The meaning and the content of this element was the subject of careful analysis in several articles and textbooks, as well as few court decisions. We will not examine this thorny element here, for our purposes, suffice is to say that among the various meanings attached to the purposes of ascribed to the particular element, DeVille's 2005 page 58 proposal is an acceptable one. He is of the opinion that it appears that inclusion of this phrase was simply an attempt to avoid challenges to administrative decision without any real impact. Activity 5.2. Having noted these various components of the puzzle of what administrative action is and inquiring into the content of the various parts, write down in one or two sentences what do you think administrative action in terms of PAJA. This is self-evaluation. You have enough information at hand to compile such a sentence or two. However, note that at this stage your answer will lack any examples of action that do not constitute administrative action. This is the topic of our next inquiry. Action that does not qualify administrative action. In this section, we will look at action decisions that are excluded from the definition of administrative action. These exclusions constitute the seventh element in the analysis of various building blocks of the definition of administrative action. Therefore, to qualify as administrative action, it must be a decision. 7. That is not specifically excluded by the list of 9 broad categories of exclusions mentioned in subparagraphs AA to II of PAJA. We could say that administrative action as defined by PAJA embraces the decisions of all organs of the state and natural or juristic person when exercising power, public power, or performing public functions. However, PAJA also excludes certain powers or functions from the definition of administrative action. In other words, some actions performed by neither organs of the state or natural juristic persons exercising public power do not qualify as administrative action. Activity 5.3, paragraph AA and II contain the list in all 9 broad categories of the exclusion decisions that do not qualify as administrative action. Make a list of these exclusions. Look up the specific sections of the Constitution mentioned in some of the categories and write down what they deal with. For example, the executive powers, function and functions of the executive in the national sphere. Examples: the president assenting to bills in terms of S84 subsection 2 paragraph A of the Constitution, the president appointing commissions of inquiry in terms of section 84 paragraph subsection 2 paragraph F of the Constitution, etc. Okay, we've got a B that we need to complete, the C, D, E, F, G, H, and I. Again, This is self-activity. However, you are uncertain about these exclusions. We hope the discussion will help you to clarify matters. Look carefully at this exclusion. We notice that 5 of these categories can be traced back to distinction between constitutional and administrative law. You will remember too that the Constitutional Court and other courts described administrative action in terms of what is not administrative action. The first 5 categories reflect this way of describing administrative action in a negative sense. Action will not qualify as administrative action when it involves the following. A. Executive powers and functions. The powers and functions of national executive. The president and the cabinet ministers are excluded, as well as those of the provincial executive, the 9 premiers and their executive councils, and the local executive municipal council. In other words, those functions at the highest level, which are constitutional in nature, are excluded. Under this exclusion, we also find the president's actions as the head of the state in the national sphere. These last mentioned actions are traditionally of the ceremonial nature and include, among others, calling of the national referendum in terms of an act of parliament, receiving and accrediting, recognizing foreign diplomatic and consular representatives, and appoint ambassadors, conferring honors, appointing commissions of inquiry, these powers are listed in section 84, subsection 2 of the Constitution and do not qualify as administrative actions, as they relate to policy and politics, the area of focus of constitutional law. In the case of pharmaceutical case, for example, the president's decision to bring an act of parliament into force by signing it was held by the Constitutional Court not to be administrative action. Jackelson P. held paragraph 79 that the president's decision to bring the act into operation required him to make a political judgment, which therefore lay somewhere between the lawmaking power, the legislative function, which was not administrative action, and the administrative process, the implementation of the legislation, which is administrative action. He had the following to say in regards to paragraph 79. When he purported the exercise of the power the president was neither making the law nor administrating it. Parliament had made the law, and the executive would administrate it once it had been brought into force. This observation corresponds to a large extent with the general exclusion of the executive powers and functions of the national executive in subparagraph AA of the definition of the administrative action. The Minister of Defense and Military Veterans versus Motau and others. The Constitutional Court that a decision by the Minister of Defense to terminate board membership of Armaments Corporation of South Africa amounted to an executive decision rather than an administrative action. This decision was founded on the nature of the minister's power. The court held that the important question in this context is whether the power is more closely related to the formulation of the policy, which would render it an executive in nature, or the implementation of the legislation, which would make it administrative, paragraph 44. In addition, the appointment or dismissal of the board members is the means by which the minister governs military procurement, which is unjust to her executive policy formulation functions. In University of Free State versus AfriForum and another 2007, subsection 4 SA 283, which was held at the Supreme Court of Appeal, the appellant challenged the university's decision to adopt a new language policy. The court held that the nature of such a decision involved the formulation and adoption of a policy rather than the implementation thereof. A decision of this kind was therefore executive rather than administrative nature. Activity 5.4. Return to the list of sections relating to executive action set out in paragraph AA of PAJA. Take particular note of the reference to section 84. Write down which of the paragraphs of section 84 are not included amongst them. Having written them down, return to your copy of the Constitution and look up what these two paragraphs provide. Write them down. There is a snag to the list of exclusion pertaining to section 84, subsection 2. Not all of the paragraphs are included in this list of PAJA. This activity compels you to read provisions in an act with care and not to be caught unaware by them. The legislative function of Parliament, the provincial legislature and municipal council. Section 1DD exclusion excludes the legislative function of Parliament, the provincial legislatures and municipal councils. This exclusion is in line with the Constitutional Court distinction between the legislative and administrative action as set out in, amongst others, the Fed Short decision. Note that this distinction also relates to the distinction between the constitutional and the administrative law. Administrative law deals with the implementation of the legislation and not with the making of the legislation through the exercise of original deliberative lawmaking powers, which is the functional area of constitutional law. Judicial function of a judicial officer of a court. The judicial functions of a judicial officer of a court, judges and magistrates, as set out in Section 166 of the Constitution, are excluded under Section 1EE. So too are the judicial function of traditional leaders exercised under customary law or any other law. Also excluded are the judicial functions of special tribunal established in terms of Section 2 of the Special Investigation Unit or Special Tribunals Act 74 of 1996. Section 1FF excludes a decision to institute or continue a prosecution in National Director of Public Prosecutions and others, Freedom Under Law 2014 subsection 4 SA, Supreme Court of Appeal 298, Supreme Court of Appeal, held that decision to withdraw prosecution also fell under the ambit of Section 1, paragraph FF of PAJA. Such a decision is therefore not administrative decision or subject to review. The decision relating to any aspect regarding the nomination, selection, or appointment of a judicial officer or any other person by the Judicial Service Commission are excluded by Section 1GG. Section 178 of the Constitution established the Judicial Service Commission to advise the government on the appointment of judges and other matters relating to the judiciary. Decision under the Promotion of Access to Information Act 2 of 2000. Decisions under the Promotion of Access to Information Act 2 of 2000, PAJA, are excluded under Section 1HH, UXTA, just administrative action in Curry and Deval, 2013, page 666, explains that this exception is for the sake of simplifying matters. Since PAJA has its own prescripts about review procedures to take into consideration when one requests information and so on, it is therefore simplifies matters considerable to exclude the PAJA from operating additional in respect of these decisions in terms of Section 4, subsection 1 of PAJA. Section 4 deals with the procedural phase of administrative action when such action affects the rights of the public. We will return to this matter when we examine the requirement of the Procedural Fairness and Administration Action Learning Unit 9. Section 1, Section 1 paragraph. I exclude from administrative action any decision taken or failure to take decision in terms of section 4, paragraph 2, subsection 1 of PAJA. The effect of this exclusion is to prevent review of administrative discretion to choose a particular procedure to follow before making a decision affecting the public. Seahawks suggest administration in Curry and Deval 2013 page 666. Please note, having looked into the list of exclusions, your first reaction to them could possibly be the following. Does this mean there is no rules apply to these actions, or is the performance of these actions above the law? The answer is definitely no. In a system of constitutional supremacy, no public action is ever above the law. However, these actions are, generally speaking, in the territory of constitutional law and are regulated by the rules and the practices of constitutional law rather than those administrative law. Therefore, these actions are reviewable under the Constitution and not under the prescripts of review set out in PAJA. Activity 5.5. Decide whether the following are examples of administrative action. Give reasons for your answer. The President signed a new Promotion of Administrative Justice Act on the 3rd of February 2000. No, the signing of legislation into law is not administrative action in terms of the provision of PAJA. The reason is that this action deals with the action of the President as a ceremonial head of state. In his capacity, he is responsible for assenting to and signing bills in terms of Section 84, subsection 2, paragraph A of the Constitution. 2. The President receives Madame Juliette as a new ambassador of France at a ceremony in the Union Buildings, Pretoria. No, in terms of PAJA, ceremonial functions of the President as the head of state are excluded. Section 84, subsection 2, paragraph H. In terms of this paragraph, the President is responsible for receiving and recognizing foreign diplomatic and consular representatives. Number 3, the Minister of Education issues a new regulation prohibition all politicians from addressing learners at schools. Yes, the making of the regulation is an administrative action. Duplessis 1998 2C page 19 explains as follows. The delegated enactment, in other words, owes both its existence and its authority to an empowering original law. He wrote further, the capacity to enact delegated legislation normally, but not invariable, vests on the organs of the executive, and the enactment of such legislation could thus, broadly speaking, be seen as administrative action. In the light of the advent of constitutionalism, legislative acts of the executive are indeed administrative action as contemplated in Section 33 of the Constitution and are therefore justiciable in terms of that section. Number 4. The Premier of Northern Province refer to a bill back to the provincial legislature for reconsideration of its constitutionality. Let me read the 5th one as well. The Director of Public Prosecution refuses to institute legal process against Lily for allegedly laundering money. Four. The referral of the bill is not administrative like the referral of the bill is not an administrative action like the president in the national sphere. A premier in the provincial sphere is responsible for referring a bill back to the provincial legislature for consideration of the bill constitutionality. See Section 127, subsection 2, paragraph B of the Constitution. No, this is specifically excluded and therefore not administrative action. See Section 1 FF of PAJA. I'm gonna stop here. I'm gonna definitely stop here because I've taken 49 minutes to do this. We are stopping here. Danko. Okay, good afternoon. Today is the 16th of February 2023. It's Thursday today. The time is exactly 17:08. We are doing ADL2601 administrative law. We were last doing learning unit 5 on page 63, where we ended on the 8th of February 2023. Now we proceeding from page 63, learning unit 5, 5.1.3. 5.1.3 Judicial Interpretation of Administration. We're going to start there today. Okay, let's proceed. The Grace Marine Howard Bay Pty Ltd versus Minister of Public Works 2005 6 SA 313 Supreme Court of Appeal SCA said the following about the definition of administrative action. The cumbersome definition of PAJA serves not so much as to attribute meaning to the term as to limit its meaning by surrounding it within a palisade of qualifications. This palisade of qualifications the court referred to is illustrated by the fact that when we need to find out what conduct qualifies as administrative action, we have to look very carefully at the various definitions in Section 1 of PAJA. we find that administrative action is confirmed to decisions in terms of PAJA. The legislature thereupon provides a definition of the term decision as well. We must therefore turn into the definition of decision to see what the legislature regards as a decision for the purposes of PAJA. However, our inquiry does not end there, since a decision is confined to conduct. A decision of an administrative nature in terms of an empowering provision. We therefore need to look into the meaning of the empowering provision as provided by the legislature as well. And because the legislature regards failure to take a decision as a decision, we need to inquire into the meaning attached to failure to take a decision too. Such decision must be taken by an administrator. So we need to refresh our memory about, among other things, the meaning of organ of state, discussed in part 1 of this study unit. What is more, the definition of administrative action is limited by certain qualification, that the decision must adversely affect the rights of any person, and that the decision has a direct external legal effect. We therefore need to inquire into the meaning and reach of these qualifications. And finally, PAJA lists 9 specific exclusions from the definition of administrative action. No wonder then the Hoxter 2012 page 195 describes the definition as highly convoluted. In Grace Marine, the Supreme Court of Appeal, which is SCA here, also adopted a broad interpretation of administrative action. The conduct of the bureaucracy in carrying out the daily functions of the state, which necessarily involves the application of policy, usually after its translation into law, with direct and immediate consequences for groups or individuals, which is part 24. The description looks simple enough. It is, after all, broad enough to cover most conduct when the exercise of public power is in evidence. Unfortunately, we find that uncertainty crops up the moment we need to apply this definition of factual situations, such as in the scenario of our first activity. This uncertainty is reflected in the huge number of court decisions since the inception of the new constitutional dispensation that deal with the question on what is and what is not administrative action. Before the enactment of PAJA, the Constitutional Court approach was to let us know what is not administrative action rather than what it is. Thus, the Constitutional Court held that the legislative action is not administrative action, nor is conduct by the President when he acts as a head of state and exercises constitutional functions considered to be administrative action. The judiciary also does not exercise administrative functions when exercising judicial functions. See scenario 5, Learning Unit 1. The two leading decisions in this regards are President of the Republic of South Africa versus South African Rugby Football Union, mentioned earlier, and Pharmaceutical Manufacturers Association of South Africa in ex parte President of the Republic of South Africa, 2002 BLCR 241cc, 2002 SA 674cc. Although both these cases have a wider constitutional and administrative law implication, we mention them here because they help us to determine whether an action qualifies as administrative action. Note that the pharmaceutical decision has important consequences for the control of administrative action as well. And we will return to it when we discuss this in the last learning unit 12. In essence, the actions excluded by the Constitutional Court are those performed by the three branches of government: the executive, legislative, and judicial, related to the separation of powers doctrine we learn about in constitutional law. Constitutional instruction. Background to Section 1. Section 33 of the Constitution reads as follows: just administrative action. 33 subsection 1. Everyone has a right to administrative action that is lawfully, reasonable, and procedural fair. 2. Subsection 2. Everyone whose rights have been adversely affected by administrative action has the right to be given written reasons. National legislation must be enacted to give effect to these rights and must A. provide the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. B. Impose a duty on the state to give effect to the rights in subsection 1 and 2 and promote an efficient administration. Section 33 is an example of where the Constitution contains only the broad framework, but in Section 33, subsection 3, has instructed the legislature, that is Parliament, to provide details. In other words, Parliament has been instructed to give effect to the constitutional provision. According to Hoxt just administrative action in Kari and Deval, 2013, page 649, to give effect to the rights means to make them effective by providing an elaborated and detailed expression of the rights to just administrative action and providing remedies to vindicate them. To vindicate in the sense to which they refer means to assert or to defend the rights. The deadline for the adoption of such legislation was February 2000. A period of 3 years from the date of commencement of the 1996 Constitution. The legislation was drafted and redrafted by the South African Law Commission, a revised Administrative Justice Bill 56 of 1999 by the State Law Advisors was presented to Parliament and finally passed by Parliament as the Promotion of Administrative Justice Act 3 of 2000, PAJA. The Act was signed by the President and promulgated in the Government Gazette on the 3rd of February 2000. This Act gives effect to the rights contained in Section 33 of the 1996 Constitution. The Act, with the exceptions of Section 4 and 10, came into operation on the 30th of November 2000. Proclamation R73, Government Gazette 21806 of 29 November 2000. Following the activity, let us just read the activity. Activity 5.6. Would you say the following examples are administrative action? The President appoints Commission of Inquiry to examine the financial position of the South African Rugby Union. The Transition Metropolitan Council of Johannesburg adopts a resolution that deals with the payment of rates and taxes by the residents of the area. Parliament adopts Refugee Act. The Minister of Home Affairs regulates in terms of the Refugees Act. The court issues an interdict against the company to prohibit the company from polluting a river. The Refugee Status Determination Officers refuses the refugees' application for asylum on the grounds that it is unfounded. The refugee appeals against the refusal of the application of asylum to the Refugee Appeal Board. When we answer these questions, we must consider them very carefully. Although the first glance, all of them may look like administrative action, not all of them are indeed examples of administrative action. And this is the purpose of this learning unit, to determine exactly when action will qualify as administrative action. And you will remember that we identified four key features of administrative law. In Learning Unit 1, we discussed the first feature, that of the exercise of state authority or public power by organs of the state, functionaries, or institute over another person in a subordinate position. The exercises of such public power or state authority is perhaps one of the most crucial features to assist us to determine whether we are dealing with administrative action and thus administrative law. In this learning unit, we will discuss the second key feature of administrative law, that of administrative action, and how to go about determining whether action indeed qualifies as administrative action. We will concentrate chiefly on the provisions of PAJA for this discussion. Let us now look into the examples given above and provide answers to the question whether the action qualifies as administrative action or not. Since the president is acting as a head of state, in other words, performing constitutional functions, the appointment of a commission of inquiry is not administrative action. You will learn more about these functions and the difference between the functions as the head of state and the head of government in the module Constitutional Law. This is what the Constitutional Court held in President of the Republic of South Africa and South African Rugby Football Union, 1999-10 BCLR 1059 CC, 2001 SA1 CC. The function is closely related to policy or politics and not to the implementation of legislation, which is administrative action. The transitional Metropolitan Council resolution is also not administrative action because it is a resolution taken by a democratic elected legislative body. It is an example of original legislation as decided in Federal Life Insurance Ltd and Greater Johannesburg Transition Metropolitan Council 1998, 12 BC LR 1458 CC, 1999, 1 SA 374 CC. The adoption of the Refugee Act by Parliament is not administrative action because Parliament is performing its legislative functions, that of enactment of legislation. When the Minister of Home Affairs makes regulations in terms of the Refugee Act, he is performing administrative action. When the Minister of Home Affairs makes regulations in terms of Refugee Act, he is performing administrative action. Regulations constitute delegated, subordinate legislation and are an example of legislative administrative action. See below. A court issuing an interdict against a company is not performing administrative action since it is exercising its judicial function. The Refugee Status Determination Officer's refusal of Theodore refugees' application for the asylum is a typical example of administrative action. Number 7. The appeal of Theodore refugee to the Refugee Appeals Board is not administrative action. The refugee is a subordinate party in a relationship. In the relationship between him and her, between him and the administrator of the Department of Home Affairs, and Theodore's decision to appeal can never be administrative action. Oh, a little bit confusing, but anyway, let's proceed. Okay. The need to establish whether administrative action is involved. It is important to determine exactly what administrative action is and whether administrative action is involved in a particular situation. The main reason for this is that the application of the right to the just administrative action, Section 33 of the Constitution, depends on whether administrative action has been performed by either the organ of the state or any person exercising public power or performing a public function in terms of legislation. In other words, administrative action is the entrance, literally the doorstep or threshold requirement for the application of the right to just administration action. You will learn more about the content of this right to just administrative action in the learning units in part 3 of this guide when we're discussing the third pillar of administrative law, that administrative action must be performed validly and lawfully. Another reason is the long list of exclusions on what constitutes administrative action. In other words, We find action that looks like administrative action but in fact does not qualify as administrative action. Okay, we're going to stop now here and then we're going to do this section for the last time in the next future. We ended up at page 66, administrative law, and we are done. Danko. Okay, we're proceeding with administration of law, ADL 2601. The date today is the 19th of February 2023 and the time is 14:12. 12 minutes past 2. So we're proceeding with learning unit 5, page 67. And we need to complete this unit. Okay, we're starting now. The classes of administrative action. The three classes of administrative action and the distinctive characteristics of each. The three classes of conduct are legislative, administrative acts, judicial, administrative acts, and C, administrative acts. Legislative, administrative acts. What are the characteristics of legislative, administrative acts? A. Legislative administrative acts are the most easily recognized action of the administration. They have a specific form and are published in an official document such as Government Gazette. See our examples of subordinate legislation in the learning unit dealing with the sources of administrative law. B. General relationships are created, varied, and or ended by administrative legislative acts. The administrative institution cannot therefore regulate this general relationship by way of a decision. If you feel uncertain about the administrative law relationship, return to that unit and look at it again. Specific rules apply to the adoption, repeal, and amendment of the legislative administrative acts. These rules are dealt with in the interpretation of status module and will not be discussed here. The power to delegation of legislative power exists only when there is express statute authority for this. We will discuss delegation in Learning Unit 7. This rule will then make more sense. E. Any administrative legislative act must be within the framework of the authority given by the original act. This means that the regulations may not conflict with any statute or restrict the provisions of a statute. Also, they may not be vague or unclear. The reason for this requirement is that the public must know what is expected of them or what they may do or not do. Judicial Administrative Acts in terms of the separation of powers doctrine. The judiciary is responsible for adjudication and settlement of disputes between individuals, between different administrators or organs of state, and between individuals and administrators or organ of state. The judiciary is also empowered to control both legislative and executive authority. The questions arises whether judicial acts are also in evidence in conduct of the administrators. The answer is yes. We do encounter judicial administrative acts, and judicial administrative act is action that is almost like that of a court. This explains its characterization as a quasi-judicial act. Like the courts, administrators interpret and apply legal rules to disputes in concrete situations. Administrative adjudication is usually undertaken by specialist bodies known as administrative tribunals. Currently, not many examples of such administrative tribunals exist, but the Films and Publications Appeal Board provides such an example. However, this situation may change since new legislation regulation public relations between organ of state and the individual increasingly provides for appeals by the affected persons to specially established boards or tribunals. It is important to keep in mind that the specialist bodies, administrative tribunals, are not courts within the South African court hierarchy, as provided for in the Constitution. Another proof of this fact is that administrative tribunals are subject to the supervision of the judiciary, that ordinary civil courts through the system of appeal and review. In other words, the ruling of the administrative tribunals are subject to judicial control. Administrative acts. This class of administrative act refer to the two administrative act where individual administrative law relationships are created or varied. Administrative acts relate to the day-to-day business of implementing and applying policy, legislation, or any adjudication decision. In short, administrative acts include literally every possible aspect of government activity, such as granting of license, promoting an employee, stamping of passport, arresting a suspect, paying out pension. Hoekstra, 2012, page 55. Police Acts. The arrest of a suspect brings a particular category of administrative act into the picture, namely that of police acts. Police acts constitutes a very special form of authoritative action since it usually takes place on a spur of a moment and in an emergency situation. Police action such as arrest, detention, and interrogation constitutes a serious infringement of personality rights. Apart from being an infringement of the right to freedom, it is common knowledge that police are often forced to act drastically to prevent crime. However, notwithstanding the widespread powers of the police. They may not do as they like. Police powers are subject to the law. Discretionary administrative acts. The particular characteristics of administrative act that involves the exercise of discretionary power warrants further explanation. The idea of exercising discretionary power is explained in the Compact Oxford English Dictionary as the freedom to decide what should be done in particular situations. A second. I need to clean my nose here. All right. We often find that administrator or organ of state has a choice about the action concerned. In other words, the organ of state has a discussion about how the action is to be performed. It is therefore has a power to make a choice between two or more alternatives. In some instances, the decision maker has a wide discretionary power. This means that the law leaves a large measure of freedom to the decision maker in his or her choice of options. We find this when a phrase such as "in his or her opinion" is used in relation to the discretion. Take the example of an application for liquor license. In some instances, the organ of state has a narrow or a circumscribed discretion. The enabling provision may lay down a number of circumstances or conditions in which the organ of state must take into account before exercising its discretion. Even though exercising a discretion entails having a measure of choice, this does not imply that the decision maker is absolutely free to act. The freedom the dictionary definition refers to notwithstanding. Even a wide discretion does not mean free discretion to act or to decide as one pleases. The choice must be made lawful, i.e. between two or more lawful alternatives and in accordance with the legal requirements. We can use a referee of a match to illustrate what we have in mind. A referee discussion during the match is governed by the rules of the game. Therefore, even though discussion involves a choice, this choice is always limited by legal rules or directives. Please note, the exercise of discretion forms an important part of administrative action. This is not the first and the last reference to discretion you will find. It features throughout the study guide, for example, when discussing the powers of the organ of state in Learning Unit 7 and the reasonableness of the organ of state action in Learning Unit 8. It also features in Learning Unit 11 and 12 when we examine administrative control. Also note that we use the words act or acts to distinguish them from the concept of administrative action as provided for in the Constitution and PAJA. The reason is that at present there is a measure of uncertainty whether legislative administrative acts indeed qualify as administrative action. We also use this terminology because, notwithstanding the statement by Du Plessis about the delegation legislation being administrative action, his view is not universal shared, as evidenced by different views expressed in court decisions. Doubt has been expressed about the need for distinguishing between the various classes of administrative action, particularly in the light of the fact that in the pre-1994 era, the classification of functions led to a rigid and insensitive application of the law. Oxter 2012, page 51, the classification remains of service, not only as an illustration of the various kinds of activities administrators perform, but also as an explanation of the consequences the law attaches to the various forms of conduct of administrators, the legal force of such conduct. These consequences will become apparent during the course of the discussion. Separation of powers and three classes of administration action. Alright, let's go. Separation of powers and these classes and three classes of administrative action. The classification of administrative action into three classes has its roots in the principle of separation of powers. If you have enrolled for or have already passed the constitutional law module, this will be familiar with this principle. The separation of powers, or trias politica, in terms of this principle. State authority is divided into legislative, executive, and judicial authority. To refresh your memory, legislative authority is the power to create, amend, and or repeal legal rules. Executive authority is the power to formulate policy and then to give effect to the policy through the execution and administration of legal rules. Judicial authority is the power to control both the legislation and the executive authority through interpreting legal rules and applying them to concrete situations when legal disputes are resolved. You will also recall that the principle of separation of powers teaches us that it is important for the state authority to be divided to prevent an excessive of power in the hands of one branch of government. This provides a way of guaranteeing that the freedom, rights, and interests of the citizens are protected against abuse of power, as it prevents a concentration of power in one institution. In administrative law, an important principle is that of deference, which entails that the court should show respect towards the powers of the administrator. The court should refer to the administrator when assessing administrative action made by the administrator. The principle is quite complex since courts are still duty-bound to assess administrative decision on certain grounds. See Learning Unit 12 specifically. In such an assessment, the court must be cautious not to usurp the functions of the executive, while at the same time it should scrutinize its decision according with the constitutional rights, rules, and principles. Department of Transport and others versus Tasima Pty Ltd, Tasima Pty Ltd and others versus Traffic Management Corporation and others. 2018 ZACC 21 and Morofeng City Local Municipality and AngloGold Ashanti Ltd 2017. Subsection 2 SA 211 Constitutional Court should the extent of which the justices differ on this principle, also referred to as the permitted extent of judicial control over administrative conduct, borrowing from and in keeping with the separation of powers principal. Administrative action is also classified into 3 classes. Furthermore, these classes of action reflect the function of the particular act. Right, then we go to activity 5.7. You will remember from your study of constitutional law and interpretation of status that legislation has certain characteristics. Return to the Refugee Act, Annexure C, page through the Act and look for provision you would regard as the reference to legislative administrative action. You will find the reference towards the end of the Act, Section 38, Regulations, to be precise. This section empowers the Minister of Home Affairs to make regulations that deal with the particular aspect relating to refugees. The Legislative Administrative Act refers to the administrative rules that are legislative in nature. It is characterized by the making and issuing of rules by the administrator when authorized to do so by original legislation. This feature is illustrated by the Refugee Act, which provides for the minister to make regulations. It is therefore a legislative act by an executive functionary. In essence, the making of regulation is what is called delegated legislation, also known as subordinate legislation in pre-democratic era. Although regulations are perhaps the best example of such delegated legislation, proclamation, directives, and orders are examples as well. Suppose there are refugee, that is activity 5.8. Let me just blow my nose again. Suppose the regulation refugee application for asylum scenario 2 has been refused. Is he powerless against the refugee status determination officer's decision, or is there any way he may challenge this? We will find that he is not powerless. He may launch an appeal against the decision with the Refugee Appeal Board. Return to Refugee Act, look up the provision relating to this board and take notes of the functions of the board. Activity 5.9. Page down to the Annexure B, the AdLife Africa decision. Read the facts carefully and then do the following. Identify the class of administrative acts involved in the facts. See whether any exercise of discretion power is in evidence. If any discretion is in evidence, this is an example of the exercise of a wide or a narrow discretion. The decision to allow the installation of pebble bed nuclear reactor is an example of an administrative act. See discussion again for the reasons why we say that. The decision to permit the installation obviously involves the exercise of discretionary power. It is an example of the exercise of a wide discretion since we do not find any requirement as to which circumstances should have been considered. However, the mere fact that it is a wide discretion does not mean that the Director General may act as he pleases. The legal force of administrative action. The legal force of administrative action refers to the effect of such action in law. We distinguish between the moment administrative action takes effect, i.e. becomes operative or comes into force, and the point when the legal force of administrative action is terminated. When does administrative action takes place? Legislative administrative acts. Administrative acts affect the individual as soon as the regulation or proclamation has been promulgated and or stated date of commencement arrives. For the distinction between adoption, promulgation, and commencement, see the interpretation of status model. Judicial administrative acts. Judicial and adjudicative administrative act usually takes effect as soon as the particular judicial institution, tribunal or board gives its ruling and delivers its judgment, unless the statute provides for a period in which an appeal may be launched. Administrative acts. Administrative acts will take effect upon the decision becoming known, either by publication or announcement in any official publication such as Government Gazette or individual notification by letter or electronic mail. It is often important to determine exactly when administrative action takes effect or becomes operative. This is necessary for various reasons, not only for the sake of Obedience, Baxter 1984, page 6, 367. But also, in order to compute expiry dates for the lodging of appeals, objection applications for review, and actions for damages, Baxter 1984, page 367. See to the last learning unit for the discussion of the control of administrative action. Okay, termination of the legal force of administrative action. The legal force of administrative action is ended by repeal or revocation, amendment, lapse time, withdrawal of the subjects of the relationship, or by court order. When the administrator or organ of state cannot amend, repeal, revoke, or vary its decision, it is said to be functus officio. Roughly translated, it means having completed the task or duty, no longer functioning. In other words, the matter has been finally dealt with, and the administrator or organ of the state is no longer able to change his or her or its mind or revoke, withdraw, or revisit the decision. In short, the organ of state has discharged his or her official function, and he or she or it cannot re-examine or change the decision afterwards. We must therefore establish when and at what moment the organ of state will be function officio. To answer the question, we must again distinguish between the three classes of administrative acts. Right, let me drink some water. Okay, let's get moving. Okay. Legislative administrative acts. Legislative administrative acts may be repealed, revoked, amend at any time. The power to repeal or amend legislative administrative acts generally relates only to the future. The repeal may not be retrospective effect, i.e. applied to the past. When an individual has acquired rights as a result of the legislative act, the repeal, the revocation, or amendment does not affect these acquired rights. Therefore, although the administrator, the legislative body, can always repeal legislative action, he or she or it cannot make it applicable retrospectively once right has been acquired. Judicial administrative acts. The administrative tribunal, such as Refugee Appeal Board, functions official once it has made its ruling, and it cannot vary or revoke the decision. Judicial administrative acts have the force to res indicator and may consequently only be altered, rescinded, or upheld by a higher judicial body, usually the High Court. Administrative acts. We must distinguish between the valid and invalid action. Invalid administrative action. Administrative action can be invalid for various reasons. In the next learning unit, we will discuss the various requirements for the valid administrative action. If any of these requirements have not been met, the administrative action is said to be invalid. The administrator may alter or withdraw any invalid administrative acts, i.e. invalid decision. After all, the administrator is a rectifying action which is defective in the first place. However, should the affected person have questioned or challenged the validity of the administrative act before a court or higher domestic tribunal, or if the individual has acquired rights, privileges as a right for such invalid administrative act, the authority cannot alter such act. Remember that the decision has individual effect. In other ways, it will not affect anyone except someone targeted by the decision. An invalid administrative act must be set aside by way of judicial review. This was confirmed in Marifeng City Local Municipality versus Anglo Gold Ashanti Ltd 2007, subsection 2, SA21 Constitutional Court. The court held that unlawful or invalid administrative action is not void or non-existent, but it exists as a fact that may provide the basis of lawful acts pursuant to it. Paragraph 36, the court also held that an organ of state must challenge any unlawful or invalid administrative act without any warranted delay. See Learning Unit 12 for more details. In Kwai-San Municipality versus Underberg, Hemville Community Watch Association, and another 2015 2A SA 257, Supreme Court of Appeal. The Supreme Court of Appeal held that an administrative body may not ignore one of its administrative acts if it is invalid. The administrative body must approach a court to have a decision set aside. Valid administrative action. We must distinguish between valid, onerous, and burdensome, beneficial, and status affecting administrative action. The administrator may alter valid, onerous, and burdensome administrative acts. Onerous and burdensome administrative acts place a duty of an individual or prohibit an individual from doing something or refuse to grant him or her something such as license. For example, the individual applies for a grant for a license and the application for a license is refused. If the official decides that the decision, though valid, may be a bit harsh, or if policy changes and so on, the decision may be changed at any stage. The reason for this rule is that the administration must be given an opportunity to correct its own mistake. Valid beneficial administrative acts may be altered by authority only where the power to do so has been conferred expressly or by necessary implication. For example, if the license has been issued, it cannot simply be revoked by the licensing officer. Where administrative act affects the status of individual, the authority may not rescind or withdraw this decision unless the revocation is authorized expressly or necessary implication. The administrator who takes a decision relating to the status is function official after he or she has made the decision. The best known example of this type of administration action is an adoption order. Activity 5.10. We have read what we have said about the legal force of administrative action, and what we have said about the functions official. In particular, go back to the decision reprinted in Annex B, the AdLife Africa decision. Would you say the decision maker was function official? In your answer, you need to explain first what the maxim functional means. Having provided an explanation, you must proceed to the application phrase to answer. To apply the maxim to the set of facts and to reach a conclusion. This is a self-evaluation activity. Go back to our discussion for the required information. Conclusion. In this learning unit, we learned about administrative action and described what it is. We learned about administrative action in a gateway for application of Section 33 of the Constitution via the provision of PAJA. We also learned about the various classes of administrative action and examined the legal force of such action. You should now be able to answer questions on these particular aspects. In the next learning unit 6 to 10 is part 3. We turn to the third pillar of the study of the administrative law, that is, the administrative action must be performed lawfully. In other words, we address the requirement of a valid or just administrative action. These units deal with the core of administrative law, the content of the right to lawful, reasonable, and procedural fair administrative action, and the right to written reasons when a person's rights are adversely affected. Okay, we're done with part 2. We're gonna save this now. We say danko.